Every single day, inventors lose millions of dollars not because someone stole their product, but because they failed to understand one critical legal protection that has existed for over 200 years. In fact, the United States Patent and Trademark Office reports that nearly 40% of patent applications contain errors serious enough to delay or destroy the inventor's rights entirely. That number should stop you cold. Because patents are not just paperwork. They are the legal backbone of innovation itself. In the next 10 minutes, you are going to learn exactly how patent law works, what it actually protects, and how inventors use it to turn raw ideas into legally enforced monopolies worth billions of dollars. We will walk through the history, the mechanics, and the real-world cases that shaped modern patent protection. And we will get to the one thing most inventors never consider: a legal clock that starts ticking the moment you share your idea publicly, and once it runs out, it cannot be stopped. Stay with us, because what you are about to learn could save your invention and your livelihood. Let us start at the beginning. Patent law in the United States traces its roots all the way back to Article 1, Section 8 of the Constitution. The Founding Fathers believed so strongly in protecting inventors that they embedded it directly into the nation's founding document. Congress was explicitly granted the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. That was 1787. The first United States Patent Act followed in 1790, and one of the very first patents was signed by Thomas Jefferson himself, who also served as the first patent examiner. The idea was simple but powerful. Society benefits when people invent. And people invent more when they know their work is protected. The modern patent system in the United States is governed by Title 35 of the United States Code, and it is administered by the United States Patent and Trademark Office, commonly known as the USPTO. As of recent data, the USPTO receives over 600,000 patent applications every single year. That volume alone tells you how critical this system has become to the global economy. But volume does not equal success. The average patent application takes between 2 and 3 years to be approved, and many are rejected multiple times before a patent is finally granted. So what exactly does a patent protect? This is where most people get confused. A patent does not protect an idea in the abstract. It protects a specific, concrete invention that is new, useful, and non-obvious. Those three requirements, novelty, utility, and non-obviousness, are the legal gatekeepers of the entire patent system. Novelty means your invention cannot already exist in the public domain. Utility means it must actually do something functional. And non-obviousness means that a person with ordinary skill in your field could not have easily arrived at the same invention. All three must be satisfied for a patent to be granted. There are three main types of patents you need to understand. Utility patents are by far the most common, covering new processes, machines, manufactured articles, and compositions of matter. Design patents protect the ornamental appearance of a functional item. And plant patents cover new varieties of asexually reproduced plants. Utility patents make up roughly 90% of all patents granted, and they are the ones most closely associated with technological innovation, pharmaceuticals, software, and manufacturing. A granted utility patent gives the inventor the exclusive right to make, use, sell, and import the invention in the United States for 20 years from the filing date. But here is what nobody talks about: that 20-year protection is not free, and it is not automatic. Inventors must pay maintenance fees at 3.5 years, 7.5 years, and 11.5 years after the patent is granted. Miss one of those payments and the patent lapses. The invention falls into the public domain, and anyone can use it freely. Pharmaceutical companies are acutely aware of this dynamic, which is why patent cliffs, the moment when a major drug patent expires, can wipe hundreds of millions of dollars off a company's valuation in a single quarter. Now let us talk about the filing process itself, because this is where inventors most commonly make costly mistakes. The United States moved to a first inventor-to-file system in 2013 under the America Invents Act. Before that change, the law protected the first person to actually invent something, regardless of when they filed. Now it protects the first person to file. That single shift fundamentally changed inventor strategy overnight. Speed to the patent office now matters more than it ever did before. Waiting, even for a few weeks, can mean losing your rights to someone who independently developed the same invention and filed first. Before filing a full patent application, many inventors file what is called a provisional patent application. This is a lower-cost, informal document that establishes a filing date without beginning the official examination process. It gives the inventor 12 months to develop their idea further and file a complete non-provisional application. During that window, the inventor can legally use the phrase patent pending, which carries real commercial weight. Investors, manufacturers, and potential licensees all respond differently to an invention that is patent pending versus one with no protection at all. The actual patent application itself must include a written description detailed enough that someone skilled in the relevant field could reproduce the invention. It must also include claims, which are the precise legal statements that define the boundaries of what the patent protects. Claims are arguably the most important part of any patent document. They are what courts examine during infringement disputes. Broad claims protect more territory. Narrow claims are easier to defend but cover less ground. Drafting claims well is genuinely an art form, which is why experienced patent attorneys can command fees that run into tens of thousands of dollars for a single application. Here is a number that puts the stakes into perspective. According to the Harvard Business Review, patent litigation in the United States costs defendants an average of $3 million per case when less than $10 million is at risk. When the amounts at risk exceed $25 million, that average litigation cost climbs to over $5 million. These are not small numbers. Patent infringement lawsuits can run for years, and the outcome can determine whether a company survives or collapses entirely. Consider the Apple versus Samsung litigation, one of the most high-profile patent battles in recent history, which stretched across multiple countries and resulted in over $1 billion in damages awarded to Apple, a figure that was later adjusted but still demonstrated the enormous financial consequences of patent infringement at the highest levels. But here is another critical dimension that inventors often overlook entirely: what a patent does not do. A patent does not give you the right to practice your own invention. That sounds paradoxical, but it is legally true. If your invention depends on technology covered by someone else's existing patent, you may still be blocked from using your own patented invention without licensing their underlying technology. This creates what the industry calls patent thickets, dense webs of overlapping patent rights in fields like semiconductors, telecommunications, and biotechnology. Navigating these thickets requires sophisticated legal strategy, and many small inventors find themselves unable to commercialize their inventions simply because larger players have built walls of patents around adjacent technologies. International protection adds another layer of complexity. A United States patent provides no protection in Europe, China, Japan, or anywhere else. Inventors who want global protection must file separately in each jurisdiction or use international treaty systems like the Patent Cooperation Treaty, which allows a single filing to initiate the patent process in over 150 countries simultaneously. Global patent protection can cost hundreds of thousands of dollars when all filing fees, translation costs, and legal fees are totaled. For individual inventors and small businesses, prioritizing which markets to protect in is a deeply strategic and often agonizing decision. The core takeaway from everything we have covered is this. Before you go, if you learned something valuable today, hit that like button right now. Subscribe to Legal Brief for a brand new video every single day. We will see you in the next one.